At Hackard Law, we've identified 10 of the most common probate, trust, and estate battles that California heirs and beneficiaries will face. Now, this is not an exclusive list, but we hope that it helps those who may be facing trust or estate litigation. And it may help to answer the question often posed. Are we the only family that is facing this kind of problem? Nope, you're far from the only family. Number 1, petitions against former trustees alleging wrongful acquisition and misappropriation of trust assets. These cases can be quite messy. Successor trustees to original settlers or makers of trust are often family members. Putting together a priority list for designation of successor trustees isn't an easy task for the makers of the trust, and the disclosure of the list to children or other beneficiaries is not always met with ready acceptance. What? What can happen when successor trustees take charge of the trust? At the death of the trust maker, the first successor in interest is appointed. This can be a readily accepted choice among heirs, or it can be an object of criticism and disagreement. New purchases of cars, boats, houses, and exotic vacations taken by the successor trustee are an invitation to suspicion. We often see the suspicion that trust assets are not being fairly administered, and maybe even wrongfully taken by the successor trustee. In those cases where family members decide to challenge the actions of the successor trustee might resign or otherwise be removed from his or her position. Under such circumstances, the new trustee gets to look at accounts and make a determination whether assets were transferred and if transferred, whether the transfers were the result of undue influence or fraud. The battleground is then set. Were the asset transfers valid gifts? Were signatures forged? And what was the mental capacity of the transferor? What was the health of the transferor? Were the gifts made consistent with long solidified estate plans? The fight goes on. Number 2, petition for court order for authorization for the settlement of an action on decedent's behalf. The good news is that cases do settle. Sometimes they settle early, and sometimes it's late. Sometimes an agreement is reached on the day of trial. When cases settle, the settlements must be memorialized, and a court order effectuating the settlement is often the wisest course of action to verify the settlement. This, of course, is not always necessary. Such court orders reserve the power of the court to address any disputes over the settlement. Disputes can occur over the terms of a settlement agreement. Unforeseen circumstances may arise that are not directly addressed in the agreement. In these cases, if the parties cannot resolve the dispute between themselves, they can return to the court for the court's interpretation of the settlement or its enforcement. Number 3, petitions by beneficiaries for instructions regarding interpretation of trust terms. Trust terms are not always clear. There may be a reference to property that is unclear. The distribution of assets to beneficiaries may also be unclear. The arithmetic indicated as to estate divisions may not add up. Life estates can present particular problems. If there is a life estate, who is to pay for the maintenance? Who's to pay for taxes? Insurance? Who's going to pay the mortgage? Other common issues are whether the value of gifts made prior to death are to be deducted from a beneficiary's share of an estate. Number 4, petition to compel return of real property to trust for breach of fiduciary duty, financial elder abuse, conversion, and imposition of constructive trust. This handful of serious allegations can evolve into protracted litigation. These types of petitions generally arise when the trust maker or his or her appointed trustee transferred real property to a new owner prior to the trust maker's death. Whether the trustee breached fiduciary duties or took unfair advantage of the trust maker to make a secret profit is often part and parcel of these claims. The trustee's duties of reasonable care and undivided loyalty, avoidance of conflict of interest, and preservation of trust property all become points of contention. Number 5, notice of proposed action for personal representative to take without court supervision. These provisions of the probate code allow for certain actions to be taken without a court hearing. Such probate code provisions allow for more expedited decision-making when all beneficiaries agree to a course of action. Number 6, citation to appear at hearing to answer interrogatories, to be examined under oath. This is what I've colloquially referenced as a scenario of, we'll see about that. We often encounter trustees, executors, or family members who think that they can suppress the existence of a will or a trust. And I suppose that they might think that possession is 9/10 of the law, but it isn't. We can bring people into court who have estate planning documents. We can have them examined under oath or ordered to answer questions that are posed to them. The availability of this remedy usually cures the document possessor's overconfidence, and the documents are relinquished to our clients. Number 7, petition for order removing co-trustee and appointing fiduciary as successor trustee and bringing trust under court supervision. We use this process when there are co-trustees that don't get along for whatever reason. Once you're a trustee or co-trustee, it's not a good idea to hide the ball. Yet this does happen. When we represent an active co-trustee who cannot get information or performance from the other co-trustee, this step comes into consideration. Another part of the process is the appointment of a licensed California fiduciary as a replacement for the errant co-trustee. Probate courts often like this approach as an alternative resolution to the paralysis induced when co-trustees cannot cooperate. Number 8, ex-parte petition for order suspending the powers of co-trustee and appointing fiduciary as temporary successor trustee and bringing trust under court supervision. This has all the attributes of the above petition for removal, but it reflects an urgency to act. Court rules require a demonstration of urgency for ex-parte petitions. In most cases, suspension can occur because of misuse of assets or the danger of the loss of assets. An interim trustee or a licensed fiduciary can come in and help protect assets during the time period between the fiduciary's appointment and the court hearing on the appointment of a permanent trustee. Number 9, petition for order suspending trustee's powers, appointing temporary trustee, compelling a forensic accounting, instructing trustee on real property. Now, this is similar to the ex-parte petition referenced above, but it is generally scheduled for a court hearing 2 or 3 months after filing. The unique part of this is the appointment of a forensic accountant to review trust records and account for receipts and disbursements. Number 10, petition to invalidate a trust amendment on forgery and undue influence. No trust funds for legal defense. Now, it's a nightmare when trust assets are spent defending what ultimately turns out to be wrongful conduct. This type of petition asks the court, and it's going to require follow-up orders, to prevent the expenditure of trust funds to defend an action to set aside a trust amendment based on forgery and undue influence. The concept is clear, but its implementation is not. There can be skirmishes and all-out battles to stop the payment of trust money for a defense that benefits only the trustee, usually as a beneficiary, and not the trust itself. Our experience is that once the decision is made to litigate, it's critical to be organized, focused, and aware that litigation itself is not a middle ground or a halfway solution. It requires a path to victory, a path that may result in resolution before trial, but resolution is possible only because a competent legal team is forging that path to victory. Hackard Law represents beneficiaries throughout California in estate trust and elder financial abuse litigation. We protect client interests throughout the state's major urban areas, including Los Angeles, Orange, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento. You can call us today at 916-313-3030 if you're facing an estate or trust battle. We want to hear your story. Thank you.